The man brought flowers. That was the detail Frances remembered afterward. A gas station bouquet, cellophane still on it, set on the tray table beside her water cup, like a prop in a play she hadn't agreed to be in. She had lived in that house for 48 years. She had raised children in it, finished paying for it, repainted the porch 3 times. The paper he put in front of her said loan agreement at the top, and she signed it because she was 68 days into a rehabilitation facility, and her reading glasses were in a drawer at home, and he had driven 40 minutes to bring her flowers. What she didn't know was that the paper was a deed. What nobody knew was that her late husband had left something in the locked workshop behind the house, something that had been sitting untouched for 14 years, that would change every calculation the investor had made. In 2022, in Los Angeles County, California, a 78-year-old woman recovering from hip surgery in a skilled nursing facility signed over her $800,000 home of 48 years to a real estate investor who told her she was taking out a loan. This is her story, with details changed to protect her privacy. Frances Alderman had bought the house on Coronado Avenue in 1974, the year she and her husband Peter married. Peter had been a Finnish carpenter, the kind who did custom cabinetry and built-in shelving and trim work so precise that contractors called him back for the same jobs for 30 years. They had one daughter, Renata, who lived in Portland and called on Sundays. Frances had worked as a bookkeeper for a small freight company until she retired in 2014. She knew how to read a balance sheet. She knew how numbers moved. But she had not been wearing her reading glasses on the morning of March 14th, 2022, and the man across from her had spoken with the careful patience of someone who had done this before. His name was listed on the document as Marcus Vale, Principal, Vale Property Solutions, LLC. He had found Frances the way he found most of his clients, through foreclosure listing alerts, public probate filings, and nursing facility discharge records obtained through a data broker. Frances had missed 2 property tax installments in 2021 while managing Peter's final medical bills and her own hip deterioration. That delinquency had placed her name on a list. Vale had visited the house once before Frances was admitted, leaving a handwritten card in the mailbox, offering to help with financial pressure. Frances had not called him. He came to her instead. His assistant, a woman named Colleen Pratt, had driven with him to the facility on Coronado Avenue and waited in the lobby while Vale went to Frances's room. Pratt's role, as Frances would later understand it, had been to serve as notary and witness. She had a portable notary seal in her bag. The entire visit lasted 22 minutes. Frances signed 3 pages. Vale told her the loan amount was $43,000, which happened to be the exact remaining balance on her mortgage. He told her the repayment terms were flexible and that no payments would come due while she was in the facility. He did not read the documents aloud. He put the flowers on the tray table and talked about the house. Did she have a garden? How long had she been there? Beautiful neighborhood. While she worked through the pages with the pen he provided. The pages were dense and single-spaced. The relevant clause was on page 2, paragraph 7. It read, "Grantor hereby conveys and warrants to grantee all right, title, and interest in the property located at." Renata found out 11 weeks later, when a new insurance billing address showed up on a renewal notice forwarded to Portland. She called the county recorder's office and confirmed the deed transfer. She called her mother's room at the facility and asked carefully whether she had signed any papers recently. Frances said yes. The loan, for the taxes, the man with the flowers. Renata flew to Los Angeles the following weekend. She sat across from her mother in the rehabilitation room and explained what the document had actually said. Frances listened without interrupting. When Renata finished, Frances was quiet for a long time. Then she said she needed her reading glasses, and she asked Renata to get them from the drawer at home. Renata drove to Coronado Avenue that evening. The house was still unlocked. Vale had not yet moved to take possession, and Frances had not yet been discharged. Renata got the glasses from the bedroom drawer, and she walked through every room the way you walk through a place when you're afraid it might not be yours much longer. At the back of the house, through the kitchen door, was a small concrete patio, and beyond it, set back against the fence line, was a structure she had forgotten about until she saw it. A low-roofed wooden workshop with a Dutch door, painted the same dark green as the porch trim, with a combination padlock on the hasp that had not been opened since Peter died in 2008. She stood in the evening light looking at it for a long time. Then, she took out her phone and called her mother and asked if she remembered the combination to the workshop lock. Frances was quiet for a moment. Then she said, "The year we bought the house. Then, the month Peter was born. 4 digits." Renata tried the combination. The lock opened. It was a Saturday in June when Renata first went inside, but she went back the following Tuesday with better light, a work lamp on an extension cord run from the kitchen outlet, because what she had seen on Saturday required a second, slower look. The workshop was approximately 16 feet by 12. Peter had built it himself in 1981, framing it out over a summer weekend and finishing the interior walls with the same attention he brought to everything else. Planned smooth, square at every corner, with a pegboard tool wall along the back and a workbench running the full length of the left side. The air inside was dry and still, the particular stillness of a space that has been sealed long enough to lose any trace of outside weather. It smelled of sawdust and linseed oil and something else, faintly metallic, that Renata associated with her father's hands. The tools were still arranged on the pegboard, in the order Peter had always kept them. 3 planes, graduated in size, hung on separate hooks. 4 chisels, blades down in a leather roll that sat in a rack above the bench. A draw knife, a spoke shave, a marking gauge, a brace with a full set of auger bits and a canvas sleeve. Renata had grown up knowing these names without knowing she knew them, the way children absorb the vocabulary of a parent's work without being taught it. She stood looking at the pegboard for a while before she started on the boxes. There were 11 cardboard boxes stacked on a set of open wooden shelves Peter had built into the right side wall. Each one was labeled in his handwriting, not the careful print he used for official documents, but the faster cursive he used for everything else, slanted slightly rightward. The labels read by content category: house records, insurance, tax 1980 to 1990, tax 1991 to 2000, tax 2001 to 2010, financial tools, manuals, Peter's father, MISC, and 2 that were simply labeled with years, 2004 and 2007. Renata started with the one labeled financial. Inside were 3 folders, held together with a large binder clip. The first folder contained bank statements from a brokerage account at a firm called Pacific Capital Management, beginning in 1997 and ending with the most recent statement dated July 2008. The month Peter had been diagnosed with the cancer that killed him 5 months later. The final statement showed a balance of $214,800. There was a handwritten note clipped to the front of the folder. Beneficiary: Francis A. Account transfer on death. See folder 3. The second folder contained correspondence. 12 letters between Peter and the brokerage, mostly routine but including one dated March 2008, in which Peter had updated the beneficiary designation to Francis and requested confirmation. The confirmation letter was paper-clipped behind it. Renata read it twice. The account had been registered as a transfer on death account, which under California law meant it passed directly to the named beneficiary without going through probate. It did not need to be in a will. It did not need a court order. It only needed to be claimed. It had never been claimed. Renata sat down on the workshop stool, a 3-legged thing Peter had turned himself from a piece of walnut he'd been given as payment on a job, and did the arithmetic. The account had been opened in 1997 with an initial deposit of $11,000. Peter had contributed to it steadily for 11 years. If the funds had sat unclaimed since 2008, they were likely held by the California State Controller's Office under the state's Unclaimed Property Program, which collected dormant financial accounts after 3 years of inactivity. The balance at death had been $214,800. With any interest applied before transfer to the state, and depending on how the funds had been categorized, the actual recoverable amount might be more or less than that. Renata opened the box labeled 2007 next. It contained a single manila envelope, sealed and labeled in Peter's hand. For Francis, in case I'm not here. Inside was a letter, 2 pages, handwritten on lined paper, dated October 12th, 2007. It was not a will. It was something more personal than that, an accounting, written by a man who had sensed, perhaps, that his body was not entirely right even before the diagnosis confirmed it. The letter listed every financial account, every insurance policy, every asset Peter believed he had accumulated. It explained the brokerage account in plain terms. It explained where to find the relevant paperwork. It named an attorney in Long Beach named Douglas Fair, whom Peter had used to draft a will in 2003. The will, Peter wrote, left the house and all personal property to Francis outright, and named Renata as executor. The will had never been probated either. Renata drove to the facility that afternoon. She brought the letter and the brokerage folder and set them on the tray table in front of her mother. She didn't say anything. She watched Francis put on her reading glasses and read Peter's letter from the first line to the last. Francis turned the second page over and looked at the back, which was blank, and then she turned it back and read the last paragraph again. Then she looked up at Renata and said, "He never told me about the account." Renata said she knew. Francis was quiet for a moment. Then she said, "He was always doing things like that." Douglas Fair had retired from active practice in 2019, but kept an office in Long Beach for state administration work. He had a client file for Peter Alderman containing the original signed will, a copy of the brokerage account designation form, and a memorandum he had prepared in 2003 summarizing the couple's assets at that time. When Renata called, he listened to the situation in full, without interrupting. He said he could not take a litigation case. That was outside his current scope. But he knew someone who could, and he would make the call that afternoon. The call went to a plaintiff's attorney named Caroline Reyes, who practiced elder law and financial abuse litigation out of an office in downtown Los Angeles. Reyes had handled 11 cases involving predatory deed transfers in the preceding 4 years. She had a specific name for what Marcus Vail had done: financial elder abuse under California welfare, an institutions code, Section 15,610.30, which prohibits the taking of an elder's property through undue influence, fraud, or misrepresentation. The statute also provided for recovery of treble damages, 3 times the actual financial harm, plus attorney's fees. Reyes reviewed the deed, the facility records, and Colleen Pratt's notary log within 48 hours. She took the case on contingency. She filed the complaint in Los Angeles Superior Court in August of 2022, naming Marcus Vail and Colleen Pratt as defendants and asserting claims for financial elder abuse, fraud, constructive fraud, and quiet title, a legal action to establish Francis as the rightful owner of record and void the fraudulent transfer. A quiet title action, Reyes explained to Renata, was the mechanism courts used when ownership was genuinely in dispute. It required the court to examine the chain of title and declare definitively who held the property. Because the deed had been obtained by fraud, it was voidable, not automatically void, but capable of being voided by a court upon proper showing. Vail did not retain local counsel immediately. For 6 weeks, he responded to filings through a paralegal service, submitting form objections that Reyes described to Renata as a stalling pattern she had seen before. The real response came in October, when a Los Angeles firm entered an appearance on Vail's behalf. Their first motion was a demurrer, an argument that the complaint failed to state a valid legal claim, even if everything in it were true. They argued that Francis had signed the document voluntarily, that the deed was facially valid, and that any confusion about its nature was a subjective misunderstanding rather than actionable fraud. Reyes opposed the demurrer and attached 2 pieces of evidence the defense had not anticipated. The first was the facility's own records, which showed that Francis had been administered a sedative medication the morning of March 14th as part of her post-surgical pain protocol. The medication was documented in the nursing notes. Its known effects included reduced alertness and impaired comprehension. The second was a declaration from a certified handwriting analyst who had examined the 3 pages Francis signed and noted that the signature on page 3, but the page containing the deed clause, was markedly less controlled than the signature on page 1, consistent with fatigue or cognitive impairment during the signing session. The demurrer was denied. Vale's team made a settlement offer in December of 2022. They would reconvey the property to Francis in exchange for a full release of all claims and a payment of $60,000 to cover Vale's claimed carrying costs. Reyes called Renata to relay the offer and let the silence sit for a moment before adding, "The treble damages exposure alone on an $800,000 property was $2.4 million, not counting attorney's fees or the punitive exposure on the elder abuse claim." She recommended declining. Renata said, "Decline." The deposition of Colleen Pratt took place in February of 2023. Pratt had been a licensed notary since 2017. Her duty as a notary public under California law was to verify that the signer was acting willingly and understood the nature of the document being signed. Reyes asked her, under oath, whether she had spoken to Francis during the signing. Pratt said she had not. She had been in the lobby. Reyes asked whether she had observed the signing. Pratt said she had come into the room at the end to apply the seal. Reyes asked whether she had verified Francis's comprehension of the document. There was a pause before Pratt answered. She said that Marcus had explained everything. That answer went into the trial record. The case was tried to a jury in Los Angeles Superior Court over 7 days in September of 2023, Renata testified. Francis, now 80 and still in Cedarbrook, gave a videotaped deposition that was played for the jury. She wore her reading glasses for the deposition. She was precise about every detail she could remember and clear about what she could not. She did not dramatize. She described the flowers. She described the pen. She described the sensation of signing something she could not fully read and trusting that the man across from her was telling her the truth. The jury deliberated for 3 hours. The foreperson read the verdict on a Tuesday afternoon. Compensatory damages, $800,000. The full value of the property. Punitive damages under the elder abuse statute, $3,100,000. The jury had used the full statutory multiplier and then some. Vale sat at the defense table and did not move for several seconds after the number was read. His lead attorney wrote something on a legal pad and turned it face down. Reyes shook Renata's hand in the corridor outside the courtroom. She said, "Your father built something solid." She meant the workshop and the boxes inside it. But she meant the other thing too. The judgment was entered in Los Angeles Superior Court on October 3, 2023. Total award, $3,900,000, inclusive of compensatory and punitive damages, with prejudgment interest and attorney's fees to be determined in a subsequent motion. The quiet title action was resolved concurrently. The court voided the fraudulent deed and restored Francis Alderman as the owner of record of the property on Coronado Avenue. The transfer had lasted 19 months. It was as if it had never happened, except that it had. Marcus Vale filed a notice of appeal in December. Reyes had anticipated this and had already moved to record the judgment as a lien against every property Vale's LLC held in California, which were 7. He could not sell or refinance any of them while the judgment lien was active. His attorney sent a letter in February of 2024 opening negotiation on a payment structure. Reyes responded with a single-page settlement offer, full payment of $3,900,000 within 90 days, in exchange for a partial release of the LLC property liens. Vale's attorney asked for a lower number. Reyes said there was no lower number and ended the call. In April of 2024, Vale withdrew the appeal and paid through a court-supervised disbursement process. The funds cleared on April 29th. Francis came home to Coronado Avenue on a Wednesday in May. Renata had arranged for a home care aide 3 days a week and had spent 2 weekends repairing the things in the house that had been allowed to slide: a bathroom faucet, a section of porch railing, a kitchen window that had been painted shut. She had not changed anything about the rooms. The ceramic dish that Frances had always kept beside the sink was there. The framed photographs on the hallway wall were in the same order they had always been. Frances walked through the house slowly, the way you walk through a place you weren't certain you would see again. She stopped in the kitchen and looked out the back window at the workshop. Its dark green paint had faded in the California sun to the color of old sage. The Dutch door was closed. The padlock hung open on the hasp, the way Renata had left it. Frances asked if she could go out there. Renata said of course. They walked out together across the concrete patio, and Frances stood in the doorway of the workshop for a long time, looking at the pegboard and the tools and the walnut stool and the shelves where the boxes had been. She reached out and touched the edge of the workbench with one hand, running her fingers along the wood the way you touch a thing to confirm it is real. She said, "He made this bench in a weekend, start to finish." Renata said she knew. She remembered. Frances withdrew her hand and stood quietly for a moment. Then she said she wanted to do something with the money that Peter would have recognized. She thought about it for 2 weeks after she was settled back in the house, and then she called Douglas Fear and asked him to help her establish a small fund. The fund was administered through a Los Angeles legal aid organization that provided free representation to elderly homeowners targeted by predatory deed transfer schemes. Its initial endowment was $200,000. Frances named it for Peter, not his full name, just his first. The Peter Fund. She told Douglas it didn't need to be grand. It just needed to work. In the 18 months following its establishment, the Peter Fund helped finance legal representation for 9 homeowners in Los Angeles County who had been targeted by similar schemes. 3 of those cases ended in full deed restoration. 2 resulted in significant damage awards. 4 were still in litigation. The gas station flowers, the ones Marcus Vale had brought to the facility on the morning of March 14th, 2022, had been left on the tray table when he walked out. A nurse had thrown them away that afternoon. Frances didn't remember them clearly, just the cellophane and the color, and the feeling of something that was meant to look like kindness. What she remembered clearly was Peter's letter, and the smell of the workshop, and the weight of the pen in her hand on a morning she had not been told enough to be afraid.